There is a promise at the heart of every courtroom that the person sitting behind that bench, the one in the black robe with the gavel, with the power to take years from a human life, is there to serve justice, not themselves. Mark Ciavarella believed in that promise too. He just found a way to make it pay. This is the story of the most corrupt judge in modern American history, and the children who paid for his greed. Luzerne County, Pennsylvania, a working-class corner of the state where the coal mines had closed decades ago and not much had replaced them. The kind of place where people knew each other, trusted institutions, and believed that the system, however imperfect, was at least trying. Mark Ciavarella had been a judge in Luzerne County for years. He was known as tough, efficient, someone who didn't waste time. Parents who appeared before him with their children described a man who barely looked up from his desk, who spoke in clipped sentences, who seemed, above all, impatient. What those parents didn't know, what nobody in that courtroom knew, was that Ciavarella had a financial arrangement with the facility he was sending their children to. In 2000, a local developer named Robert Powell had built a new juvenile detention center called PA Childcare. It was a private facility, and private facilities, unlike state-run ones, generated profit. The more juveniles they housed, the more money they made. Powell needed a steady supply of occupants. Ciavarella needed money. The conversation that followed changed thousands of lives. To understand what Ciavarella built, you have to understand how a juvenile court is supposed to work. In Pennsylvania, as in most states, juvenile offenders, children under 18 who commit minor infractions, are entitled to legal representation. They are entitled to have their cases heard fairly. They are entitled, above all, to proportionality. A first offense, a minor offense, does not send a child to detention. It results in probation, community service, counseling. That was the law. That was the promise. Ciavarella dismantled that promise case by case. Hillary Tranzu was 14 years old when she appeared before him. She had created a mock MySpace page mocking her school's assistant principal. It was a prank. Juvenile, yes, possibly cruel, but a prank. Ciavarella sentenced her to 3 months in detention. Her parents had been told the hearing would take minutes, that she would come home with them. She didn't come home for months. Shane Bly was 13. He had been caught trespassing in a vacant building with friends. He was sentenced to 2 consecutive terms in boot camp. Kurt Kruger was 14. He had been present, not participating, simply present, when a friend shoplifted a jar of nutmeg. He was sent away. These were not dangerous children. They were not repeat offenders. Many had no prior record at all. But in Ciavarella's courtroom, the outcome was nearly always the same. Ciavarella's detention rate for juvenile offenders was roughly 5 times the state average. Judges across Pennsylvania were sending perhaps 10 or 15% of juvenile defendants to detention. Ciavarella was detaining close to 60%. The numbers were extraordinary, and for years nobody asked why. The arrangement between Ciavarella and Robert Powell had been structured to look legitimate. Powell had paid Ciavarella and a second judge, Michael Conahan, ostensibly as consultants, as advisors, as men whose expertise in the juvenile justice system was worth compensating. In reality, the payments were direct, consistent, and tied to the continued flow of juveniles into PA Childcare and a second facility that Powell later built. Between 2003 and 2006, Ciavarella and Conahan received a total of $2.6 million. The money was spent on a condominium in Florida, on home renovations, on the kind of life that a county judge's salary, respectable but not extravagant, could not have supported. Conahan, for his part, had used his position as the presiding judge to quietly shut down the existing county-run juvenile detention facility. This left PA Childcare as the only available option. There was nowhere else to send the children. The machine was complete. Ciavarella sentenced them. Conahan eliminated the alternatives. Powell collected the profit and paid them both. The scheme unraveled not because of a federal investigation, not because of a whistleblower inside the system, but because of a public defender named Marcia Levick. Levick worked for the Juvenile Law Center, a Philadelphia-based advocacy organization. In 2006, she began noticing something unusual in the cases coming out of Luzerne County. The detention rates were impossible, the sentences were disproportionate, and in case after case, juveniles had appeared before Ciavarella without legal representation, without anyone explaining to them or their families that they had the right to a lawyer. Levick filed a formal complaint with the Pennsylvania Supreme Court. It was initially dismissed. She filed again and again. It took 2 years, but eventually the numbers became impossible to ignore. The Pennsylvania Supreme Court ordered an investigation. Federal prosecutors were brought in. And in January 2009, Mark Ciavarella and Michael Conahan were indicted on federal charges of racketeering, fraud, and conspiracy. When the full scope of what had happened became public, the reaction in Luzerne County was unlike anything the community had experienced. Parents who had watched their children be taken away, who had blamed themselves, who had wondered what they had done wrong, finally understood. It hadn't been justice. It had been a transaction. Ciavarella initially attempted to negotiate a plea deal. It fell apart when he refused to fully acknowledge his guilt. He went to trial instead and lost. In 2011, Mark Ciavarella was convicted on 12 of 39 counts, including racketeering and conspiracy. He was sentenced to 28 years in federal prison. Michael Conahan, who cooperated with prosecutors, received a lighter sentence of 17.5 years. Robert Powell, the developer who had built the facilities and initiated the payments, received 18 months of house arrest. The Pennsylvania Supreme Court took the extraordinary step of expunging the records of approximately 2,500 juveniles whose cases Ciavarella had adjudicated. It was an acknowledgement that those proceedings had been fundamentally corrupted, that the sentences handed down in that courtroom were not sentences at all. They were invoices. For the victims, the expungement came too late to undo the damage. Children who had been sent to detention had dropped out of school, had developed criminal records that followed them into adulthood, had carried the weight of a system that had decided for $2.6 million that their futures were for sale. Mark Ciavarella maintained, even after his conviction, that the payments from Powell had not influenced his sentencing decisions, that he had been tough on juvenile crime because he believed in accountability, that the money was coincidental. The jury did not believe him. But the question this case leaves behind is not really about Ciavarella. It's about the system that allowed him to operate for 5 years without scrutiny. The administrators who saw the numbers and didn't ask. The lawyers who noticed the patterns and stayed quiet. The appeals processes that failed the children who had no one to advocate for them. Ciavarella exploited a gap, not a gap in security or in the law, a gap in attention, in the assumption that the person behind the bench was doing what they were supposed to do. The most dangerous corruptions are not dramatic. They don't announce themselves. They happen in ordinary rooms, in ordinary proceedings, under ordinary fluorescent light, while everyone assumes someone else is watching.